Well, good morning. I'm Todd Cotta. I'm the owner here at the King's Gun Center. My dad and I and my family own the store here. We've been doing it now for 8 years, just this last 5th of June. A couple days ago, the Supreme Court came out with a ruling. The ruling has been misunderstood mostly by people that are talking about it, because when the news talks about it, they talk about how bad the ruling is and how dangerous it is. Just like if they were to, people have said, hey, we should get a ballot initiative in California to get our gun rights back. Problem is, if we make it a ballot initiative, the Secretary of State gets to name the ballot measures, right? So if it is a let's give criminals freedom, let's make drugs legal, they're going to call it the Safe Schools and Neighborhood Act, Prop 47. Prop 47 was called the Safe Schools and Neighborhood Act, but it lowered penalties for drugs and released prisoners from prison. If we were to put a gun measure on the ballot in California, they would call it the School Shootings and Massacre Bill. They would make it the worst name possible, and I guarantee you, San Francisco and Los Angeles, who have the voting bloc in this state, would say no to it. And then what are we? We're in a worse position than we started if actually the voters voted on it. So we have to rely on the court sometime. We have to rely on people that have shown that they have been hurt by these laws. And this is what happened today with the New York Rifle and Pistol Association, just like the CRPA. They filed, because in New York State, you have to have a license for a handgun in your house. You have to have a license for a long gun in your house. And if you want to drive around town or go to the range, you have to have a permit to drive with one pistol, and if you get caught, it's a felony. If you fly into the airport with a gun in your baggage, you're automatically arrested, even though it's locked, even though it's TSA approved, even though it's federally shipped correctly. They'll arrest you at the gate once you touch your bag. So New York filed suit. It went to the Supreme Court this week, and everybody heard that it changes CCWs, correct? It changes, and it does. Basically what it does is it makes all states a shall issue state. Right now, California, New York, and a bunch of other states, 43 states right now, or 46 now, are shall issue states. Meaning, if you are a legal citizen, here legally, if you have no felony background and you have no mental background, you are automatically issued a CCW for asking. Now, each state can have criteria, like we have the class and those kinds of things, but you don't have to put a cause statement in. I drive at night, I make deposits, I have family, all those things that we have to do for here, that's gone. Now, Gavin Newsom has already said he's not going to abide by the federal law, but in time, it will right itself when it comes to the way it was written. Good news, right? Good news. But that's only a little tiny piece of what happened with that law. Just a little tiny piece. I'm going to read this right now. Chuck Michel is the California's #1 gun attorney. He is the leader of the CRPA, the California Rifle and Pistol Association, and he has defended cases all the way to the Supreme Court in the past. I'm going to read his statement right now, and then any questions afterwards, we'll talk about it, okay? It's called Supreme Court Rules in Favor of Second Amendment. June 23rd, 2022, the Supreme Court has issued an opinion in the long-awaited New York State Rifle and Pistol Association versus Bruen. Until this opinion, it had been 10 years waiting for the Supreme Court to take up another Second Amendment case, seminal Heller case, which guaranteed the right of all individuals to keep and bear arms. Now, in this latest court case, it has once again sided with the Constitution, and millions of gun owners have been under the oppression of the thumb of the politicians in the passing unconstitutional laws. Basically, states like California and New York were restricting your fundamental rights, and they got caught. This case details two basic issues. One, the issuance of concealed carry permits under a regulatory proper cause regime. We just talked about that. But here's the one that's exciting. Two, the standard under which Second Second Amendment cases can be heard by the courts. Okay? The first issue is easy. The Supreme Court made it very simple. New York and other states that have a good cause requirement issuing a CCW are unconstitutional restrictions on the rights of gun owners. Justice Alito, in the concurring opinion, the inherent right of self-defense, Heller explains that the central to the Second Amendment right, that is what our attorney at Michael and Associates have been arguing for decades. The California Attorney General admitted in statement that the California process for issuing CCW is unconstitutional under this ruling, even as Governor Newsom has begun threatening gun owners with new punishments and new laws because of the ruling. Right after it happened, Newsom put out a post saying, we don't care what the Supreme Court says, we're going to be California and do what we want to do. He's already done that. Governor Newsom began threatening gun owners with punishment and the new laws because of the ruling. We will challenge those just like we did this one and win. Second issue is one of the standard of review by the courts. While we did not get the strict scrutiny that we hoped for, we did get a test that is devastating to most government claims to their laws and infringe on the rights of the people. In the past, courts have used the two-step balancing test for a Second Amendment claim. This typically viewed by the Second Amendment claim as a lesser light that gave the government the ability to trample on the rights of the law-abiding citizens. The court said the Second Amendment is the very product of an interest balancing by the people, and it surely elevates above other interests the rights of law-abiding responsible citizens to use arms for self-defense. Heller, Justice Thomas said, the court has little difficulty concluding that also the plain text of the Second Amendment protects Koch's and Nash's proposed course of conduct, carrying a handgun publicly in self-defense. Nothing in the Second Amendment draws a home public distinction with respect to the right to keep and bear arms. The definition of bear naturally encompassed public carry, right? Basically, the court concluded that the Second Amendment cases should be viewed under a test of history and tradition and with an eye towards the historical existence as restrictions to the Second Amendment when the Second Amendment and 14th Amendment were passed. Governments now must bear the burden of proving that whatever restrictions they want to place on your rights was a restriction when the Second Amendment became into being. This is a huge burden for the government and not one to be easily met. Michael and Associates, California Rifle Pistol Association, the Second Amendment Law Center have been fighting these types of unconstitutional laws for decades, and we've been winning. Now we look to the next line of cases that are currently lined up in the Ninth Circuit and the Supreme Court by adding some of the most marks against the Second Amendment. So basically, he's just kind of patting his back right there. So, yes, we have a shall issue order from the Supreme Court, which makes getting a CCW nationwide much easier, especially in places like Alameda County, Sac County. In Santa Clara County, the last person to get a CCW had to give the chief of police a $35,000 basically bribe to get their permit. It'll make all states shall issue. But here's the important one. We have cases right now on the ammo at the Ninth Circuit. The way they're making our ammo backgrounds, ammo ban. We have cases regarding the handgun roster right now going to the Ninth Circuit. So we can get our Hellcats, we can get our 365s, we can get our Gen 5 Glocks. Those are there now. We have the AR-15 ban in New York and California going to the courts right now, going to the Supreme Court. The Supreme Court's going to throw all those cases back down to the circuit courts and says, if you're going to look at these cases, you have to look at it from the goggles of our founders and only do one test. Does it meet the standard of the Second Amendment? And if it is no, that law is violated. We get our rights back. That's what's cool about this ruling, is they have to look at the cases again, and we'll start seeing our petitioners winning cases against the states now when it comes to them taking away our gun rights. That's why it's so important that this case happened. This has been a crazy week at the Supreme Court. America was burning again last night, right? Because we got to kill babies. But that is in a nutshell, what happened with that court case. The CCW thing, the concealed, they said you still have to ask. You still have to have a permit to carry, but they can't ask you why. And if you're legal to do it, you're approved, which is a great step forward for gun rights.